The selfie taken by a monkey sparked a legal battle that cost one photographer over $1 million, all because of an unexpected twist in copyright law. Imagine traveling halfway around the world, spending thousands on equipment, only for a wild animal to press the shutter button on your camera, creating an image that shakes the very foundations of intellectual property. This wasn't a joke or a marketing stunt. It was a real federal lawsuit in the United States, with real money on the line and implications for every creator. The core question was simple yet profoundly complex. Who owns the copyright to a photograph taken by a macaque monkey? The answer, as it turned out, was far from straightforward and exposed a critical gap in U.S. law that most people never consider. But the story gets even stranger as a major animal rights organization steps in, claiming the monkey itself was the rightful owner. British nature photographer David Slater traveled to an Indonesian jungle in 2011, hoping to capture intimate shots of crested macaques. For days, he patiently observed the monkeys, trying to get them comfortable with his presence and his equipment. He set up his camera on a tripod, pre-focused it, and even rigged it with a remote trigger. But then, something truly extraordinary happened. A curious male macaque, later named Naruto, approached the camera, examined it, and with a mischievous grin, pressed the shutter button repeatedly. Among hundreds of frames, a few perfect selfies emerged, clear, charming, and undeniably unique. Slater published these photos, including the now famous monkey selfie, and they quickly went viral worldwide. He believed, naturally, that he owned the copyright. After all, it was his camera, his equipment, and his creative setup. But the internet, and later a very serious legal entity, had other ideas. This is where the legal nightmare began for Slater. The initial controversy wasn't about ownership, but about whether the photos should be freely available. Wikipedia, for instance, argued the images were in the public domain because a non-human animal couldn't hold copyright, a position that stripped Slater of potential earnings. Then, in 2015, the animal rights organization Peta, or People for the Ethical Treatment of Animals, filed a lawsuit in a U.S. federal court in California. Peta didn't just argue against Slater's ownership. They argued on behalf of Naruto, the monkey, claiming he was the author and therefore the legal owner of the copyright. This was an unprecedented move, pushing the boundaries of legal personhood and intellectual property in ways no one had anticipated. Peta sought to administer the copyright for Naruto's benefit, intending to use any proceeds to protect the macaques and their habitat. Slater was blindsided, now facing a legal battle not against another human, but against a monkey represented by a powerful organization. The stakes were suddenly enormous. To understand the core of this case, we need to look at U.S. copyright law. The Copyright Act of 1976 states that copyright protection subsists in original works of authorship fixed in any tangible medium of expression. Crucially, the U.S. Copyright Office's Compendium of Practices, which guides examiners, explicitly states that it will not register works produced by nature, animals, or plants. It further clarifies that to qualify as a work of authorship, a work must be created by a human being. This seems pretty clear, right? If only it were that simple. Peta's argument hinged on the idea that the Copyright Act's language didn't explicitly exclude animals, and therefore could be interpreted to include them. This legal gray area created an opening for their novel claim, forcing the courts to consider whether a monkey could be an author in the eyes of the law. This wasn't just about a selfie. It was about a fundamental interpretation of who or what can be a legal rights holder. Peta's legal strategy was aggressive and groundbreaking. They argued that because Naruto intentionally pressed the shutter button, he was the primary author of the photograph. They pointed to the fact that Naruto initiated the action, and therefore, under a broad interpretation of copyright law, should be recognized as the copyright holder. They argued that denying copyright to Naruto was speciesism, akin to historical denials of rights to certain groups of humans. Their lawsuit, filed in the U.S. District Court for the Northern District of California, sought to establish a trust for Naruto, with Peta as his representative, to manage the income generated by the photos for his benefit and the benefit of his fellow macaques. This was a direct challenge to the human-centric nature of intellectual property law and, if successful, would have set a monumental precedent, extending legal personhood and rights to animals in an unprecedented way. The legal community watched, utterly captivated by this bizarre and potentially transformative case. David Slater, on the other hand, argued that he was the rightful copyright owner. His defense wasn't that he took the picture directly, but that his creative input was essential. He traveled to the remote location, purchased and set up the expensive equipment, understood the nuances of light and composition, and created the scenario where the photo could even be taken. Without his efforts, the camera wouldn't have been there, and the selfie wouldn't exist. He also leaned heavily on the U.S. Copyright Office's clear stance. Only human beings can hold copyrights. Slater also detailed the significant financial burden this lawsuit placed on him. His legal fees quickly mounted, reportedly reaching into the hundreds of thousands of dollars. He faced immense pressure, not just from the legal battle, but also from public opinion, as the story gained global attention. This was not just a legal fight for him. It was a fight for his livelihood and his reputation as a professional photographer. The costs were becoming unbearable, even for an internationally recognized photo. In January 2016, U.S. District Judge William Orrick III delivered the first major ruling. His decision was unequivocally in favor of David Slater, stating that the U.S. Copyright Act does not extend to animals. Judge Orrick explicitly affirmed the long-standing principle that copyright protection is limited to original works of authorship created by human beings. He reviewed the legislative history and the Copyright Office's regulations, concluding that there was no legal basis to grant copyright to an animal. While acknowledging Peta's admirable intentions, the judge stated that extending legal personhood and copyright to animals was a matter for Congress, not the courts. This ruling seemed to put an end to the bizarre saga, upholding the traditional interpretation of copyright law. But Peta was not deterred. They immediately announced their intention to appeal, ensuring the legal battle would continue, pushing Slater's financial and emotional limits even further and keeping the question of the monkeys' rights alive. Peta appealed the district court's decision to the Ninth Circuit Court of Appeals, a higher federal court. This move meant the case would be reviewed by a panel of judges, potentially setting a binding precedent for the entire western United States. During the appeals process, the legal arguments became even more detailed, with both sides presenting extensive briefs and oral arguments. Peta continued to press their unique interpretation of the Copyright Act, while Slater's legal team reiterated the human-centric nature of copyright. The appellate judges, however, expressed skepticism about Peta's standing to sue on behalf of Naruto, questioning whether Peta could legally represent the monkey's interests in court. This procedural hurdle, known as standing, became a critical point of contention, separate from the core copyright question. If Peta lacked standing, the entire lawsuit would be dismissed, regardless of the merits of Naruto's copyright claim. This procedural twist added another layer of complexity to an already strange case. Just as the Ninth Circuit was preparing to issue its ruling, a surprising development occurred in September 2017. David Slater and Peta reached an out-of-court settlement. Under the terms, Slater agreed to donate 25% of all future revenues derived from the monkey selfie photos to charities dedicated to protecting Naruto and his habitat in Indonesia. This was a significant concession from Slater, considering his initial stance and the financial strain he'd endured. Peta, in turn, agreed to drop their lawsuit, effectively ending the 7-year legal saga. The settlement meant the Ninth Circuit did not issue a final ruling on the merits of Naruto's copyright claim, nor on Peta's standing. This left the central legal question unanswered by a binding precedent. which was both a relief and a disappointment for legal scholars. While the case closed for Slater, the broader implications for animal rights and intellectual property remained an open debate, still echoing in legal circles today. One common myth that emerged from this case is that the monkey actually owns the copyright. This is incorrect. Despite the settlement, U.S. copyright law, as interpreted by the U.S. Copyright Office and the District Court, still requires a human author for copyright protection. The settlement was a practical agreement to end litigation, not an admission that Naruto held the copyright. It was a strategic move to stop the bleeding of legal fees for Slater and achieve some benefit for the monkeys for Peta. Another related misconception is that if an animal takes a picture with your camera, it automatically becomes public domain. While the Copyright Office states non-human works can't be registered, the exact legal status of such a work if a human facilitated it remains a fascinating, albeit unresolved, question. The takeaway is clear. Under current U.S. law, animals cannot own copyright, no matter how clever their photography skills might be, which is a key point for any creator to understand. Slater's mistake wasn't in letting the monkey take the photo. It was arguably in underestimating the legal and public relations storm that would follow. Had he perhaps immediately dedicated a percentage of earnings to wildlife conservation from the start, he might have preempted Peta's lawsuit. He reportedly spent over $1.5 million in legal fees and lost income over the years, a staggering sum for photos that initially brought him fame. This illustrates a critical lesson for creators. Even seemingly absurd legal claims can incur immense financial and emotional costs. For instance, if you're a content creator and your work goes viral, a misstep in attributing ownership or failing to protect your rights can lead to similar, devastating legal battles. Always be proactive in understanding copyright, even for the most unconventional scenarios, because a lack of clarity can quickly turn into a financial black hole. The cost of $1 million lawsuit shows that the legal landscape is fraught with unexpected dangers. The monkey selfie case offers vital lessons for every creator, especially those in photography and digital content. First, understand that under U.S. law, authorship for copyright purposes is currently limited to human beings. If a camera is set up, but an animal triggers it, the human who set up the shot, framed it, and intended to create a work might still have a claim, but it's a gray area. Secondly, be prepared for unexpected challenges to your intellectual property, especially if your work gains viral attention. The internet loves to debate ownership, and powerful organizations can leverage public sentiment. Thirdly, consider proactive measures. Clearly watermark your work, register your copyrights with the U.S. Copyright Office, and understand licensing agreements. If you're involved in a project with unconventional elements, consult with an intellectual property lawyer before it becomes a problem. The cost of prevention is always less than the cost of litigation, which David Slater learned the hard way. Remember, an ounce of legal foresight is worth a pound of legal fees. The monkey selfie case is a wild, unforgettable chapter in U.S. legal history. While Naruto never officially became a copyright holder, the case forced a critical examination of who or what can be an author and pushed the boundaries of animal rights in the courtroom. It reminds us that intellectual property law is constantly evolving and often tested by new technologies and unexpected circumstances. For creators, the key takeaway is clear. Protect your work, understand the nuances of copyright, and never assume common sense will prevail in a legal battle. The strange journey of a camera, a monkey, and a selfie changed one photographer's life forever. If you found this deep dive into U.S. legal cases fascinating, be sure to subscribe to the channel for more true stories from the American courtroom.